Welcome back. You're watching NewsX with me, Riyadh Dwivedi. Now let's take a look at the top story of the hour. The US Supreme Court has cleared the extradition of Tahawwur Rana, a convict in the 2008 Mumbai terrorist attacks, to India by dismissing his review petition. India had been seeking Rana's extradition, a Canadian national of Pakistani origin, as he is wanted for his role in the attacks. This decision marks the end of Rana's legal avenues to avoid extradition. He had previously lost multiple legal battles in federal courts, including the United States Court of Appeals for the Ninth Circuit in San Francisco. On November 13, Rana filed a petition for writ of the certiorari with the US Supreme Court, which was rejected on January 21, a day after Donald Trump assumed office as president. The court simply stated, petition denied. Tahawwur Rana, a Canadian national of Pakistani origin and one of the accused in the Mumbai 26/11 attacks, has been handed over and extradited to India. Diplomatic efforts are underway to facilitate Tahawwur Rana's extradition to India. So before we get into that, I want our viewers to understand the reply to the opposition, and this is one of the arguments and the copy of that. And when we talk about that, this you can see on your screens is the Supreme Court of the United States, and the reply to opposition on petition for writ of certiorari to the United States Court of Appeals for the Ninth Circuit that we have been talking about earlier. So, but before we get into that, I want to talk about the arguments that have been stated in that. The argument, the circuits are clearly split. The split in the circuits is clear and irreparable absent a decision from this court. The 4th and 9th circuits have expressly rejected the 2nd Circuit's holding and that they termed the offence in the extradition double jeopardy context and refers to conduct rather than element. So that's what and they have denied. For these reasons, they denied to follow Sedona's same conduct framework and adopt the Blockberger same elements test as the proper mode of analysis in this context. And for its part, the 2nd Circuit has never retreated from Sedona. It remains the law there. And the government has also pointed to a single district court case that adopted the element standard despite Sedona. So when we're talking about that, the government has suggested that the 2nd Circuit might overrule Sedona given developments in domestic double jeopardy law since that case was decided. When we're talking about the next about this arguments that we are seeing, these inconclusive textual references aside, courts that adopt the element standard appear to look principally to domestic double jeopardy law. And the government also maintains that no square conflict exists because the wording of the article containing the United States-India Treaty's double jeopardy provision differs slightly from the analogous article in the United States-Italy extradition treaty interpreted in Sedona. So, but when we are talking about the government has further insisted that the court should deny review because the issue arises only infrequently. But now taking a look at more of that, these arguments, the district courts as well have addressed the meaning of offence in double jeopardy provisions of extradition treaties in some instance such as NLOC, with no appeal have been taken from the ruling. Now let's take a look at more of these arguments. Even if the question should be said to arise infrequently, however, the significance of the interest involved in each such case warrants this court's review. This case illustrates the point, and having been acquitted in United States District Court on charges relating to the Mumbai attack, having served his sentence and which was reduced on compassionate grounds for the crimes of which he was convicted. So you can see here, this is what the court has said. This case illustrates the point. Having been acquitted in the United States District Court on charges relating to the Mumbai attack, having served his sentence, reduced on compassionate grounds for the crimes of which he was convicted, and having languished in jail for 4 years while his extradition case has proceeded through the courts, having endured all that, Rana now faces the prospect of transfer to a country where his birthplace, Pakistan, his religion, Muslim, and the nature of the charges, terrorist murder of 166 people, mark him for likely abuse followed if he survives pre-trial incarceration by a trial with a predictable result and execution by hanging as per the IPC. And Rana faces this grim prospect solely because he had the misfortune of being incarcerated in California at the government's sole discretion if the government had housed him in New York, Connecticut or Vermont. He would have the benefit of Sedona's conduct standard and he would have been released long ago. A man's life and freedom should not turn on the happenstance of where the government chooses to imprison him. Now we're talking about the argument number 2. This case is an excellent vehicle to resolve the circuit split. The government does not dispute that Rana preserved the double jeopardy issue at every point in the court below or that those courts squarely address that issue. Instead, it suggests that the conduct versus elements issue might not be outcome determinative because the conduct at issue in the Chicago case could differ from the conduct underlying the Indian charges. And the government occasionally hinted at this argument. During the years, this case made its way through the lower courts, but it did not identify any Indian charge that rests on different conduct than the Chicago charges. And we're also seeing that is that if it adopted the conduct standard to remand to the extradition court to decide in the first instance whether Rana's prior prosecution bars his extradition under a conduct-based test, but without identifying any Indian charge that would survive the test. And now the government suggests that the Indian conspiracy to commit forgery charge might rest in part on conduct not involved in the Chicago case, and that is incorrect. The portion of the Indian extradition request to which the government points and alleges that David Headley used the cover provided by Rana's business while in India. He presented fabricated and falsified documents to the Reserve Bank of India with an application to open the branch office for the business in Mumbai, which was rejected. Rana had, in fact, directed the attorney at the Immigration Law Center to prepare documents to support David's cover story, including documents given to the Indian authorities to establish the business. These documents identified David when we're talking about David as a representative of the Immigration Law Center, despite the fact that he had no immigration expertise. Now, when we're talking about this, yet this alleged conduct was plainly included in the Chicago case. And in a bill of particulars, the Northern District of Illinois prosecutors identified Rana as expert advice and assistance, to include Rana providing his immigration business expertise to establish and seek the necessary approval to operate an immigration business in Mumbai, India, for the purpose of providing a cover to the co-defendant Headley. And the Chicago indictment alleged that the material support Rana conspired to provide included false documentation and identification. A bill of particulars identified the false documentation to include co-defendant Headley's application for an Indian visa containing false information. In short, the Indian conspiracy to commit forgery charge encompasses in conduct directly at issue in the Northern District of Illinois prosecution. Even if the government were correct about the conspiracy to commit forgery charge, however, that would not render the case less worthy of this court's review. The government does not contend that the conduct underlying the most serious Indian charges, which is waging war, murder, committing a terrorist act, and conspiracy to commit these crimes, could survive a conduct-based double jeopardy analysis. If double jeopardy barred extradition for those charges and Rana were extradited only on the conspiracy to commit forgery charge, the rule of speciality embodied in Article 17 of the treaty would prohibit Rana's prosecution in India for any other charge other than conspiracy to commit forgery. That would remove the possibility that he would be subject to the death penalty or life imprisonment. Thus, even if the government were correct that the conspiracy to commit forgery charge would survive under a conduct standard, the controversy would still have life or death consequences for Rana. And when we talk about the next argument, the government is wrong on the facts and on the merits. The government spends much of its brief on its view of the facts and the merits. None of this bears directly on whether the court should grant review, so we respond in summary form. The government devotes almost 2 full pages to the alleged facts. What it omits, however, is that those facts come largely from the record of Chicago trial, and in particular from David Headley's trial testimony. Yet, in acquitting Rana on the Mumbai-related charges, the jury necessarily rejected Headley's testimony about Rana's alleged involvement in the Mumbai attacks. And for good reason, as Rana demonstrated below, Headley embodies Judge and former federal prosecutor Stephen Trotz's observation that criminal informants are cut from untrustworthy cloth and must be managed and carefully washed by the government and the courts to prevent them from falsely accusing the innocent, from manufacturing evidence against those under suspicion of crime, and from lying under oath in the courtroom. And when we're talking about Headley, he has spent much of his adult life doing the things about which Judge Trott warned. And this court should give no more weight to the Headley's testimony than the Chicago jury did. And the government's discussion of the merits largely parrots the Court of Appeals' analysis, which we addressed in the petition. And there are 3 points that are highlighted here. When we're talking about the first point, the government does not dispute applying the elements test in a dual sovereignty double jeopardy regime renders the double jeopardy protection nugatory, the concern that led the Second Circuit in Sedona. Second, the government insists the courts must defer to the executive branch's technical analysis of the treaty's double jeopardy provision, even though that analysis provides no reasoning. But courts and commentators have analyzed deference to the executive treaty's interpretation to the Chevron deference. When we are talking about, the government insists that the court must defer to the State Department's interpretation of an ambiguous term in a treaty that agency negotiated. When we're talking about the third thing, the government dismisses as an inartful reference United States Attorney Patrick Fitzgerald's invocation of the United States-India Extradition Treaty as the basis for the conduct-based double jeopardy provision in Headley's plea. And the government ignores both the requirement that federal prosecutors obtain approval from main justice for extradition provisions in plea and Rana's repeated request. So that's the petition and the arguments that we have talked about in terms of this case. It's a big win for India that now we're seeing the US Supreme Court has cleared Mumbai terror attack convict Tahawwur Rana's extradition to India. We have with us Sambhav Sharma joining us on the telecast. Sambhav, when it comes to this big win, this US Supreme Court has cleared Mumbai terror attack convict Tahawwur Rana's extradition to India. What exactly are the arguments that took place in terms of this extradition request?
Well, yes, absolutely. It's not just a big victory, a big legal victory, but also a diplomatic victory. And it's a big win for India from the United States Supreme Court, wherein the Supreme Court of the United States, the top court of the United States, approved the extradition of a 2008 Mumbai attack mastermind accused Tahawwur Rana, and extradition has been approved to India, and an appeal was filed in the Supreme Court of the United States. It was a writ appeal in the top court of the United States against the lower courts, where it was asked that extradition should be stopped. However, and another very important thing which is to be noted here is that the petition was denied by the top court of the United States, the Supreme Court of the United States, a day after Donald Trump assumes the role of the United States
All right, Sambhav,
president.
we also have with us Ambassador Pradeep Kapoor, former diplomat, joining us on the telecast. Ambassador Pradeep Kapoor, when we talk about a case like this, and there was also a lot of claims by Headley's testimony against Tahawwur, and when we're talking about that, what do you think and assess it in terms of the Headley's testimony against him?
Well, firstly, Ria, I must compliment you for a very brilliant exposition. You have explained it very, very nicely, the entire background and the basis and the facts of the case. So that is very useful to all the listeners who are listening in onto this, broadcast, telecast. What I would like to say is that these things are very important in bilateral relations. There are mutual legal assistance treaties with many countries which facilitate such extradition requests, and the views of the courts are very important. The views of the government are very important. Currently in the US, we have an atmosphere where the new president has taken over, Donald Trump. His views on terrorism are very clear, and the views of the people who have voted for him are very clear. And the immigrants who are illegal in this country are being deported. They have started being deported. So cases of terrorism like this, where Islamic jihadis have, created havoc in a city like Bombay, in November 26, 2008, is finally coming to fruition. It has been a long slog, and I'm happy that the Supreme Court has now rejected the petition of this terrorist, Canadian-American terrorist Tahawwur Rana. It was clearly established in India that he was involved, and he should have been extradited to India long back to face whatever that he deserved. So in Chile, when I was there in 2011, one of the most feared terrorists in the world, called Abdul Rauf, who was brother of Masood Azhar, was caught at that time in Chile. We didn't have any mutual legal assistance treaties with Chile, but because of our excellent, networking and excellent linkages with the government and the senior authorities, we were able to bring it to a point where he could have been easily extradited. But then there was some intervention which was very negative from China, and somehow we had to stop our process of getting him back to India. So now, after that, he created havoc in Pulwama and Pathankot and other places. So some of these terrorists, they continue doing all this, terrorism, act of terrorism. If we didn't had to release Masood Azhar because of this case of plane being hijacked, even 9/11 would not have happened, because Masood Azhar, Abdul Rauf, all of them were directly concerned with 9/11 also. So what I'm trying to say is that with Donald Trump now in power in the US, all the allies
all
of
right,
the US...
Ambassador Pradeep Kapoor, I'd also like to get Rudra Vikram Singh, Senior Advocate, Supreme Court, to join in this conversation. Rudra Vikram Singh, when it comes to a case like this, what do you think is the next phase after this, when it comes to him getting the extradition request being approved, and after US Supreme Court passing this, what do you think is the next plan? Would there be more things will be revealed later on, and how do you assess this ruling?
See, this is a big win for India, big win for legal battle for Indian government, because now the Supreme Court of the United States has approved that approved the extradition of the Tahawwur Rana. And what was this? As you asked that, how I see this judgment of Honorable Supreme Court of the United States, Tahawwur Rana has contended that there is a jeopardy, as you said in your introduction also. So I would like to understand the viewers what is double jeopardy. Double jeopardy is this, that one person cannot be prosecuted or punished for a same offense. So that was the main contention of the Tahawwur Rana before Honorable Supreme Court of United States. But you know, this Supreme Court he was acquitted by the Court of Chicago, by the lower court of the United States. So that was his main contention, that I am acquitted from the lower court of the United States. So again, if there will be prosecution in India, that will be case of double jeopardy. That is against criminal jurisprudence. So that was denied by Honorable Supreme Court of the United States and said that no, there are some charges against you of forgery. There are some charges of making illegal application on the basis of illegal documents, which you have established some office in India. So there are few cases which is left, which has to be
All right,
prosecuted in India.
Sambhav
So,
Sharma,
on
Ambassador
that
Paradeep
contention-
Kapoor and Rudra Vikram Singh, thank you so much for joining us on the telecast and sharing your insight on that. Moving on, ceremonial welcome of